Hello students, welcome to Legacy IAS Academy. Today we are going to discuss about Foreign Contribution Regulating Act, also called as FCRA in short, and we are going to discuss about what is the issues that is playing this particular act and why there are so much disputes going on, why there are so much protest that is going on regarding this particular act. So let us start and delve deeper into this particular topic. So first of all, if we try to understand the context in which we are discussing today's topic, is because recently the Supreme Court of India has asked almost around 6,000 NGOs that is non-governmental organizations, to go back and meet with the government and governmental representatives for redressal of their grievances as far as the non-renewal of their FCRA registration is concerned. In this particular area, almost 5,900 NGOs are there whose licenses has not been renewed by the government, citing several reasons, mostly either the criteria or registration criteria has not been fulfilled, or the renewal application has not been submitted by the agencies or NGOs. And the NGO which has filed this petition was the Global Peace Initiative, and based on this petition, the Supreme Court has directed about this particular matter. Now, if we try to understand the background of this very important act, that is FCRA. So, FCRA registration of about 5,900 NGOs ceased to become effective or active after December 31, 2021. And the main reason was because they have not been applying for renewal before the due date, or in some cases or in some NGOs cases, the Ministry of Home Affairs have refused for renewal of the registration because some NGOs have involved in a violation of the act as alleged by the MHA. Also, MHA refused to renew the FCRA registration very recently. It was in news last month. The Mother Teresa's Missionaries of Charities, whose license was not being renewed. However, later on, the license was renewed and it was renewed up to 2026. But initially, the Missions of Charity also has to face several problems because of some adverse inputs that MHA has received from the Intelligence Bureau. Now, if we try to understand that what is the aim of the Foreign Contribution Regulation Act, why this act was passed or initiated. So, main aim of this act was to regulate foreign donations that is coming to the countries, to any non-governmental agencies or even any private individuals who is involved in some kind of social work or social activities. But at the same time, the government also wanted to ensure or make sure that any such individuals, associations or organizations, they do not function by taking the help of these foreign funds. They do not function in a manner which is not consistent or adverse to the values of the sovereign democratic Republic of India. So if we try to look at the brief history of how the FCRA has evolved in India. So first of all, it was enacted in year 1976. It was a time during which the then Prime Minister Indira Gandhi has imposed emergency, and that is the time when this act was enacted for the first time. And the main reason behind inaction was, though the demand for enacting such acts were made in Parliament as early as in year 1969. However, in 1976, to ensure that foreign powers, like especially if we talk about foreign intelligence agencies, because at that time both Soviet Union as well as the United States of America wanted to increase their assertiveness over New Delhi, over Indian government, and that is why the act was enacted. So the foreign powers, be it Soviet Union or United States of America or even foreign intelligence agency like CIA, MI6 or KGB, are not able to interfere in India's affair by pumping in large amount of money, foreign money, through independent organizations like NGOs or other social organizations. Further, the next important development happened in year 2010, when under the then UPA government that was led by Prime Minister Manmohan Singh, the amendment was done where the act was consolidated, all the laws or the provisions of the act were consolidated, and especially the consolidation was done on those matters where utilization of foreign funds, and to ensure that to prohibit and use for any activities that is detrimental to the international interest, that is detrimental to the national interest. So it was ensured by enacting certain provisions that no foreign fund that is flowing into India for helping NGOs should not be involved in any kind of activities that can be detrimental to the national interest. Further, the next amendment happened recently in year 2020 under the current government of Bharatiya Janata Party, where more title control and scrutiny over the receipt and utilization of foreign funds by NGOs were made. So now if we try to understand that what are the significant provisions, what are the main provisions that make the FCRA a very important act. So first of all, the FCRA enables any agency if they want to take the benefit of foreign funds, they have to mandatorily register under the Act, and at the same time, they have to also open a bank account for the receipt of such foreign funds in only one bank, that is the main State Bank of India in Delhi. This is very, very important provisions, and this is also one of the point of criticism that NGOs says, that because of this limitation that NGOs can only open their account in State Bank of India Delhi, especially those organizations who are based in South India, or those organizations who are based in Northeastern India or the Western India that is very, very far away from Delhi, they have to face several troubles, several problems, that they have to move every time to Delhi and they have to tackle with the State Bank of India of Delhi. So this was the criticism point. Second, it also says that funds utilization, all the foreign funds that any NGOs receive will be utilized only for the purpose for which they have been received and as stipulated in the Act. That means they will not have any wherewithal, they will not have any such kind of openness to spend the fund without first of all enacting them, without first of all declaring them in the whatever the registration licenses they have got. Third, you try to understand, it also says that all the NGOs or business, all the NGOs or we can say agencies as well as the individuals, they have to annually file returns, and they must not transfer to funds to another NGO. That means whatever fund they are getting or receiving in their own name, it should be spent by their own organization, not by any other subsidiary organization or the this sister or brother organizations. And at the same time, it also make a very important provisions that the FCRA prohibits any receipt of foreign funds by any individual who is candidate for any elections or is a journalist or belonging to newspaper and media broadcast agencies. Also, the judges and government servants are not allowed to receive foreign funds, members of legislature and political parties too, and their office bearers, as well as any organization which is mainly working or has a kind of political nature, are forbidden for receiving any kind of foreign funds, either for the social welfare work or any other kind of work. Now, let's try to understand and look the registration process, at how FCRA registration process happens. So, first of all, it is granted to those individuals or associations that have a definite cultural, economic, educational, religious and social program. These are the 5 major heads under which the licenses can be given. Either the program should be, or the working of any particular organization should be in the field or area of cultural, or field of region of economic, education, religion, or any kind of social programs. Then once the application is made, all the documents is given by the agencies or organizations that are interested in getting the licenses. Then the Ministry of Home Affairs, through its agency, that is Intelligence Bureau, try to look into the antecedents of such individuals and organization, and they try to see that whether the inputs are good or inputs are adverse. On basis of that, then MHA issues the licenses. However, MHA has clearly stated in its guideline that any individual organization that is applying for the FCRA licenses should not be fictitious or benami. Benami means that it should not be such a case that someone else is applying on the name of other. The person or organization who is applying for the licenses, they should give and furnish all the documents and should be present also at the time of application. Second, it also said that it should not have been prosecuted. The individuals who are applying for licenses, they will not get the license if they have been prosecuted or convicted in any such activities that is aimed at forced conversion. Conversion means religious conversion you're talking about. Then any individuals, if they are involved or has been convicted before in forced conversion from any one religion to the other religion, they also are not eligible for application of licenses. Third, it also said that the individuals should also not have been convicted or prosecuted for creating any sort of communal tension or disharmony in the society, and also they should not have been involved or prosecuted for any activities that amount to sedition as far as the law of sedition in India is concerned. On base of all these report, if the person, individuals, organization fulfill all these 3 criteria, they are not coming under any of these limitations, then the Ministry of Home Affairs is required to approve or reject the application within 90 days. That means within 90 days they have to say that whether the license has been provided or whether the registration has been successful or unsuccessful. Further, however, MHA has also been given the power that if a time or if need arises, they can even cancel the approval even if it is given by MHA before. Now, cancellation of approval can happen or occur on the various grounds. Out of these, the 6 are the most important one. First of all, MHA can cancel the approval if any individual has involved or taken part in activities that is in violation of the Act. Second, if they have made any kind of statement that is false in nature in the application. Third, if they are not or they have not been engaged in any such activities that they have mentioned in their application for consecutively 2 years. That means if any organization is not doing work for the welfare of people or for the benefit of community and society for continuously 2 years, then also their licenses can be revoked. Also, in terms of public interest, whether it is security reason, health reason or morality reasons, the approval can be cancelled. Not only that, even if any organization is involved in financial irregularities, and especially that with respect to misutilization of foreign funds or either merging of domestic funds and foreign funds or not spending foreign funds where they have shown their intent to, then these are the valid grounds on basis of this MHA can cancel the approval of the particular organization as far as the FCRA Act is concerned. However, after cancellations, if any organization's registration is cancelled, then they are not eligible for re-registration for at least 3 years. 3 consecutive years. After 3 years, again they can apply for fresh registration, and again looking upon the merit of the cases, the MHA can grant again the license. However, against all these powers that has been provided to MHA under the Act, there are certain provisions are also there that has been that has been included in the Act to ensure that NGOs' rights and interests are also protected. So first of all, the provision is that there is reasonable opportunity of being heard. That means no NGOs or organizations licenses can be cancelled or the registration can be cancelled without giving them opportunity so that they can put their own viewpoint, put their own defense in place or against the MHA, and after that, hearing their viewpoint, the MHA can take the appropriate decision. Also, there is a security that has been provided from the judiciary point of view. That means all the decisions or all the orders of government regarding to cancellation, renewal or this granting of new licenses can be challenged in the High Court. So obviously, if the organization or the individuals is not happy with the decision of the government, they can challenge it in the High Court, file a petition, as we have seen initially that it was done. Now, the most obvious question that comes or that keeps coming in media is that is the FCRA Act is continuously being used for targeting of NGOs? So let us try to understand this, that why this question has come into media. So first of all, you try to understand that until year 2011, there are more than 40,000 NGOs that were registered under FCRAs. But in last 8-9 years, lot of NGOs licenses have been cancelled, and per the recent data in year 2021, now the NGOs who are registered under FCRA has just fallen down to 16,000. So almost 24,000 NGOs are there whose licenses has been revoked or whose approval has been cancelled. And if you try to understand this is not happening every year. But if you look, the major cancellations happened not only in this particular government, BJP government, but cancellations also happened during the UPA government. For example, in 2012, 3,922 NGOs licenses were cancelled. Similarly, in 2015, 4,004 licenses were cancelled. So depending on how the situation emerges or what are the inputs the government gets from the intelligence bureau or from different agencies, as well as how the NGOs are acting, whether they're acting in interest of the nation or not in the interest of the nation, based on a lot of factors, variety of factors are there, the government makes its mind and take the particular decision. So obviously, if you try to understand in recent time, in the most recent time, which are the major NGOs or what are the major NGOs who are coming under the scanner of government or whose licenses has been revoked, cancelled, or some limitations have been placed on their working. So first of all, we have Compassion International. Compassion International, its license was revoked because the government and IB has said that the Compassion International is involved in forced religious conversion, which is a valid ground of cancelling of licenses. Then we have Greenpeace India. Greenpeace India's license was also cancelled because it was involved in mismanagement of foreign funds, or the foreign funds were not being utilized for the purposes which they had declared. Similarly, the Amnesty International, very important organization, its license were also cancelled because they were involved in activities that was not in the interest of India. They were serving the foreign interest. On this ground, government has cancelled the licenses. Similarly, we have Sabarang Trust. Sabarang Trust license was cancelled because they were given they were supposed to be involved in communalization activities. They were publishing this magazines also, which were kind of communal in nature, and they're also mixing the domestic fund with the foreign funds. So this kind of mismanagement is going on. That is why Sabarang Trust license, it is an organization that is led by a very famous social activist, Teesta Setalwad. So its license was also cancelled recently. Then we have Ford Foundation. Ford Foundation's license has not been revoked, but it has been put under the prior request category by the Ministry of Home Affairs. That means if they have to take or they have to receive any foreign contribution, they have to first take approval, prior request, or it is also called as prior approval category. Means the Ford Foundation, before taking any of the foreign contribution, have to take approval from Ministry of Home Affairs, because it is believed that Ford Foundation was also acting not in the interest of country, but was acting with a foreign interest in the mind, and that is why they were jeopardizing the national security of the country. So on this ground, Ford Foundation has been put in this category. Similarly, we have Lawyers Collective that is led by Indira Sohani. This NGO's license was also not renewed because same problem, they were involved in some kind of financial mismanagement, and basically government has says that whatever funds they were receiving from the foreign sources, most of them were used for politically motivated actions. That means the political regions or political spheres were there where they were mostly active, and not for any social or economic work. On this ground, the government has decided to cancel the license. So these are some of the recent examples, and we can see that the government time to time enacts and changes and amended the law as per the changing need that is felt in the country. On basis of this, the government has taken these particular decisions. So that is all about. We try to understand this particular video. What is Foreign Contribution FCRA Act? What are its main provisions, and what are the issues surrounding it? What are the criticisms and what are the concerns of NGO around that? So I hope you like the video. If you like, please share and subscribe. We'll come again soon, another interesting video. Till then, take care. Thank you very much.